This is the balance of the presentation on is that worker an employee. We're going to pick up where we left off on requesting a tax court determination. Section 7436 allows the U.S. Tax Court to determine employment tax issues, including misclassification, as well as the calculation of FICA, FUTA, and income tax. Section 7436 is only for service consumers. Unfortunately, workers are not able to argue status. Now, a Section 7436 filing doesn't have to be the first step. Service consumers can start by seeking an appeal. In this process, the IRS will first send letter 950-C. That's known as the Employment Tax 30-Day Letter, a notice of adjustment to employment taxes. This can be accompanied by Form 13683, Statement of Disputed Issues for adjustments less than $25,000. So what does the employer do upon receipt of this form? The employer can then submit a letter to appeals with a statement of any disputed adjustments, as well as the background details and explanations to support these assertions. After this, the employer will have a chance to meet with an examiner before proceeding to appeals. Now, if no response is filed within 30 days, or if the IRS appeals process goes awry, the IRS will likely respond with letter 3523. Now, 3523 is what's known as a Notice of Determination of Worker Classification, or NDWC for short. And that letter indicates the misclassified employees that need to be recategorized. If a service consumer would still like to fight back, the service consumer has until the 91st day following the postmark date on the NDWC to petition the tax court. So essentially, that is the access to tax court. Basically the fact that the 91st day following the postmark date on the NDWC allows the taxpayer, in this case the service consumer, to petition the tax court. However, things may not get better in tax court. They use a 20-factor test similar to the 20-factor test used by the IRS. However, it is not a 20-factor test, actually. It's a 7-factor test that's used to determine employee classifications. Under that 7-factor test, the tax court reviews the degree of control by the service consumer, the source of facilities funding, the opportunity for profit or loss, the ability to discharge a worker, whether the work being performed is a part of the service consumer's regular business, the permanence of the relationship, and the relationship the parties believe they were entering into. Once again, if the amount being disputed is under $50,000 for each quarter, the taxpayer can request a judicial review as an S case or a small claims case that falls under the umbrella of Section 7436. Those cases tend to move a lot faster than the normal case, but it's important to note that there's no appealing the ruling. Both sides forfeit the right to additional appeals by proceeding with an S case. Employee misclassification steals billions of dollars from the government every year and hurts countless good employees just trying to earn an honest living. At the end of the day, the best situation for everyone is perhaps, of course, excluding the unscrupulous employers who plan on just going on being unscrupulous. The best situation is to classify employees properly the first time around, and to stay up to date on rulings to be sure things don't change to the detriment of you, your clients, or even your company. If you have any questions regarding the presentation, feel free to hit me up anytime on LinkedIn, Twitter, or simply by sending me an email at mjdebliss@theblisslaw.com. You can find more information about this and several other issues relating to tax law at my website, and that's located at www.theblisslaw.com.